And the clerk, please. The Honorable Supreme Court of the State of Mexico.
Great, you may be seated. Thank you. We're on the record S-1-SC-39949 State versus Jones. Please enter your appearance. You have 23 minutes in opening.
My name is Thomas Lewis. I'm here on behalf of Mr. Jones. Good morning.
Good morning.
Mr. Jones's case poses the question of whether an open porch or portal is part of a structure within the ambit of our burglary statute. This should be a simple case for this court to resolve because this court has already done the appropriate analysis in its case of X-Rail Mukdeen. We ask this court to apply the Mukdeen analysis to the facts of this case and find that there is no burglary by entry onto a portal and reverse Mr. Jones's conviction. In Mukdeen, this court undertook a review of New Mexico burglary cases, and after a thorough review of recent jurisprudence in this area, concluded that the lower courts had gone astray.
Can I ask you to clarify just something early on? You said reverse his convictions and then remand to the district court, and what happens?
There are two possibilities. Under this court's case in Oya, if we find that there is legal insufficiency to sustain the conviction, the remedy is a direct remand and entry of a judgment of conviction for the lesser included offense of second-degree murder. Alternatively, since the trial court instructed the jury on all of the lesser included offenses, not only of homicide, but also of burglary, there is a possibility, by lesser included, I also mean attempted burglary, there is a possibility that the jury may have found Mr. Jones guilty of attempted burglary of a portal, which under our argument would be legally insufficient. In that situation,
Mr. Lewis, I've got a question, and it may be throwing a wrench in your whole argument. And let me explain. The criminal information count 1, first-degree murder, felony murder during the commission or attempted commission of aggravated burglary. Count 1. The instructions to the jury, instruction 12, find defendant guilty of first-degree murder as charged in count 1. The state must prove that the defendant committed or attempted to commit the crime of aggravated burglary. 2, Jones caused the death of Mr. Romero during the commission of aggravated burglary or the attempt to commit aggravated burglary. 3, Joseph Jones intended to kill or knew that his acts created a strong probability of death or great bodily harm. The jury was then instructed in instruction number 18 that to find him guilty of aggravated burglary, the defendant was armed with a firearm, among other elements. The jury was also instructed on attempt, instruction number 19, that the defendant began to do an act which constituted a substantial part of the aggravated burglary. And the jury was also returned a verdict. We find the defendant, Joseph Jones, guilty of felony murder as charged in count 1. If, assuming we accept your arguments on the portal not being part of the dwelling, is he not guilty under the instructions to the jury and the finding of the jury of attempted aggravated burglary as the predicate felony for felony murder?
that's an interesting question, Your
It's
Honor.
not only interesting, it's critical.
Well, let me address this. The jury was instructed not in the existing UJI 14-14-10. The trial court amended it by adding the words or portal after dwelling or structure. So it is impossible to know whether the jury based its verdict on a finding that the attempt was burglary of the portal or the dwelling.
Attempted burglary. When he jumps the wall using this bucket, goes into the yard, they find his gun, and the wife wakes up, she sees him fighting, sees him with a hoodie on around his face. He yells at her, "Go call the cops." She hears the shot. The assailant is gone. Her husband is dead there by the fence. They find his glasses. They find glasses. They find a gun, which are then matched to this Mr. Jones. Isn't that sufficient for the jury to find attempted aggravated burglary as a predicate felony to felony murder?
But I would have to disagree with Your Honor. The way the jury has been instructed, it is possible that the jury based its verdict on attempted burglary of the portal, not of the dwelling. It's impossible to know.
The instruction on felony murder doesn't say anything about the portal. He says that the defendant committed or attempted to commit the crime of aggravated burglary. They defined a dwelling. There is a definition of a dwelling in instruction 23 as any structure or any part of which is customarily used as living quarters. But that's got nothing to do with attempt.
Well, again, I would disagree with Your Honor. I believe that the jury may well have been guided by the district court's addition of the words portal in the main burglary instructions. So they may have been finding Mr. Jones guilty on the basis of legal nullity, which is burglary of a portal.
Attempted burglary of a portal.
Attempted burglary of a.
So an attempt, would he have to enter the portal? That's your whole premise, is that the portal is not a dwelling. But attempt doesn't mean you have to commit the crime to commit the attempt.
But you can, if you are attempting to do something which is not a burglary offense to begin with, which is.
That's what I'm saying.
The way the jury
Your
is
argument is
instructed.
that you have to commit the burglary to be guilty of the attempt.
Judge, I would disagree with you. I think the jury has been misdirected, has been misinstructed by the district court. And so from their point of view, following the court's instruction, they were led to believe by the instruction that the portal had the same protection under our burglary statute as the dwelling, and that is not the case.
So counsel, let me see so in the main burglary instruction, the court adds the language to the dwelling language, adds or portal in the main burglary.
Correct.
In the attempted burglary instruction, or portal is not found. Is that accurate?
I can look it up if the court will indulge me.
We're, a few of us over here are struggling with, where does the or portal language get added
It is,
to the attempted
it is
aggravated
definitely,
burglary?
That's instruction 19, I believe.
I would draw the court's attention to instruction number 18. Were you to find the defendant guilty of aggravated burglary, the defendant entered a dwelling house or structure or portal without authorization.
So that's the main burglary.
Correct.
Mhm.
And then instruction 19 is the attempt.
The defendant began to do an act which constituted a substantial part of the aggravated burglary, which refers back to 18, which
Okay.
incorporates the language or
That's-
portal.
Yeah, that's helpful for my mind. So I appreciate that. So 19 simply references 18.
Correct.
So let's, if I may, not move so fast past this idea that portal is not a structure. All right. You're arguing Office of Public Defender case, and in your opening you say dismissed all previous cases regarding whether structures are part of a dwelling. Looking at the case, number one, it doesn't dismiss Gonzalez, 194 P3rd 725, 145 New Mexico 110, where I think if I have the order right, Judge Pickard clearly states that enclosed area connected to a store is a structure. That's established. It doesn't overturn Gonzalez, distinguishes a different Gonzalez case, but leaves it alone. Oliphant, Pickard was on, I believe that panel, or wrote it, wrote it. And then it's on the panel in Gonzalez. So if you go to Oliphant, Judge Pickard knows about Oliphant and writing Gonzalez and says, this is a structure. Justice Boston at the Court of Appeals is on one of those panels, writes for the Supreme Court. It doesn't get rid of Gonzalez, but instead says, under enclosure, paragraph 10, prohibited space is a private space. It is the nature of the enclosure that creates the expectation of privacy. As the California Court of Appeals stated, the proper question is whether the nature of a structure's composition is such that a reasonable person would expect some protection from unauthorized intrusions. Why would this individual not have some expectation of protection from someone entering a portal attached to the house? And if not, would that be a question for the jury?
Judge, may I begin by just responding to your discussion of the Gonzalez case? This court in McLean did not overrule Gonzalez outright, but it did severely criticize the reasoning of Gonzalez. First of all,
Not the portion under enclosure, which is what we're talking about. Where did they do that?
in their discussion of the rule of eius generis,
I'm sorry.
in the court's discussion of the rule of eius generis.
Okay, I'll go back. Go ahead. '78, New Mexico, 219. I may have my Gonzalez's mixed up.
You're a raft.
Or they do.
You're a raft.
Or they published it twice.
You're a raft of Gonzalez cases.
All right, well, I'm interested in the one that says a structure attached to a hardware store is sufficient for burglary. That's the one I'm interested in.
Well, in McLean, the court includes its reference to the Gonzalez case in its discussion of cases where it's clear from the opinion that this court is looking askance at the excesses of the lower courts and extending the meaning of the ambit of the burglary statute.
That's fair.
So it's not that this court has endorsed Gonzalez. It lumps it in together with the most extravagant burglary cases, which are Rodriguez. That is
I apologize. I don't see that. But on rebuttal, if you can tell me where they lump Gonzalez in, they do exactly as you described. And I totally understand that when someone's trying to get burglary by puncturing a gas tank. But I do not see, I apologize, them lumping Gonzalez in with those, but I'll look more closely.
And Your Honor, I'd like to answer the second prong of your question, which is that someone climbing the fence into someone's backyard is unnoticed that he or she is breaching privacy, but the privacy that is being protected by a backyard fence is not the same as the privacy interest that's protected by the four walls and the roof of the dwelling.
Why not? I mean, I have an 8-foot wall, pretty big, gates. Then I have another 4-foot wall, and then I have a portal. I mean, when I say I do. Why isn't all of that sufficient notice that going into my portal is a no-no?
Actually, I have the same layout in my house.
Got a lot of walls.
Well, I don't have the inner wall, but I have it.
I have both the outside 8-foot wall, inner wall, portal, and my portal is attached to my house.
With all due respect, the degree of alarm that I would feel if I saw an intruder in my backyard at 2 a.m. is not the same as the degree of alarm that I would feel if the intruder were standing in my living room. It's a totally different animal. And the degree of privacy that the burglary statute was intended.
What if I'm sitting on my portal watching a movie, eating popcorn, and somebody is in my backyard?
It is a trespass, not a burglary, because as this court said repeatedly in Mukdeen, burglary, it goes all the way back to the common law notion of what a burglary is. And under the common law, there had to be a breaking and an entry. With the evolution of the law, we've done away with the breaking aspect. You don't have to break into someone's house with a hammer or something to be a burglary, but there has to be an entry. And you can't have an entry without an enclosure. I think that's
The wall is sufficient enclosure, and they're entering over the wall into this private space where some people consider their second living room, maybe.
well, patio furniture doesn't make a dwelling. This court in Mukdeen approved the Court of Appeals decision in Fluenthal. And Fluenthal is all about that. It's just that someone climbing over a fence at Repo Ranch to do heaven knows what at Repo Ranch is not the same thing as a burglary. It's a yard full of things
So what if my portal is screened in, a very flimsy, got holes in it, ratty New Mexico screen?
There is a gray area, but I would agree with this court that a screen with a door is more of an impediment. And to get through the screen, you have to do an entry. Whereas if you walk onto your portal, it's not the same thing. You're walking onto something. You're walking under a roof, basically.
I'd add my dog would disagree with you on all of this.
My dogs would greet you.
Yeah.
Mr. Lewis, but I understand your argument, but why is it not an attempt? Assuming you have the requisite intent and so forth, going into the yard with the intent to do the burglary while armed, why is that not attempt?
Because the district court instructed the jury. So on the basis of the numbers 18 and 19, the jury could say that if you were trying to burglarize the portal, which I argue you can't do, that is sufficient to support felony murder in this case.
So counsel, do you agree that one of the remedies available would be to remand for a new trial on felony murder using an attempted burglary as the predicate felony?
Correct. That is a possibility because of the uncertainty of whether the jury verdict was reached on the basis of a legal insufficiency. That is the burglary of the portal, which my argument is that it's a legal knowledge that you can't do it.
So you also mentioned that you thought that we could do a direct remand for entry of a second-degree murder conviction. Is that right?
Right. Because in Tafoya, this court has said that where insufficiency or legal insufficiency doesn't support a felony murder verdict, the court may do it in touch remand or treat the second-degree murder.
Now, Tafoya didn't have the facts that this case has in that there was not a felony murder claim that was at issue. How do we decide between a new trial remand on felony murder and a second-degree murder direct remand?
The court's decision in that regard would have to depend on whether the court believed that the jury verdict represented two possible lines of logic by the jury. One is that the jury believes that its attempt is for attempted burglary of the dwelling, which would be legally sufficient. The other possibility is that the jury followed its direct language of number of construction number 18 and believed that the attempted burglary of the hotel in that case would be insufficient. So under the case of Campos v. Let me look it up.
Bravo. Campos v. Bravo.
Yes, correct. Then the remedy would be.
So what are you asking? What do you think we should do between those two options?
We are asking for the remand, or among other reasons, to grant closure to the parties.
What is it? What is the standard for what's the standard for a structure then, under your interpretation, State Office of Public Defender? Is it, which seems new to me, that it has to have walls? Are we going to be debating whether or not I have an interest in my privacy and not to be intruded upon? Or are we going to have a contractor out there measuring to see if there's walls and windows? What is the standard if there's some other type of structure or building?
Well, there are different degrees of privacy that one would have an interest in
We're
protecting.
arguing over walls and windows. We're not, is the standard privacy?
The court's opinion in McDean lays great stress on the entry aspect of the burglary statute. So you can't enter into something if there's no impediment to your entry.
Except they sit, well, but they're careful to make the exception if it's an open window. There's no impediment in an open window.
Except that if you go through a window, you're transgressing through the barrier of the wall that surrounds the window.
So you want walls.
If it's any help to the court, this court could take judicial notice of the building code of the city of Santa Fe, which defines gross living space is the area within the.
My point is, we're arguing over construction and not what I believe state public defender was getting at, which is, does a reasonable person have an expectation that sitting in their portal, they're not going to be intruded upon? Is that not the test?
But the degree of expectation of privacy for a yard is not the same as the same expectation that you have for your
That's
living room.
full font. I agree. Okay. I press the point. Sorry.
So I would also like the court to address the fact that the district court erred by misinstructing the jury. The UJI general criminal instructions say that you don't tamper with the language of the UJI without specific reasons to do so. And in this case, doing that, the district court basically instructed the jury to convict our client of felony murder. So it not only does it mislead the jury as to the nature of the law, but it also.
It matters at all that the fact that the portal is connected to the dwelling, it's physically connected, as opposed to a fence that's not. Is there anything that bears in that analysis with respect to the expectation of privacy?
The portal is connected to the dwelling on the side. It is open to the yard, it's open to the elements. In this case, there was nothing to impede someone who had already trespassed onto the yard from strolling onto the portal. There was no entry per se that had to take place for that to happen. So the degree of privacy violation is trespass.
Thank you, counsel. Any other questions? Thank you.
Well, Your Honor, if you have no further questions, I'll sit down.
Thank you very much. About our 30 minutes.
Chief Justice Thompson, members of the court, counsel, good morning. My name is Peter O'Connor. I'm here to represent the state of New Mexico. This case is about the invasion of privacy and the violation of a victim feeling violated, actually being violated in a space where he had an expectation of privacy and security. Victim's portal was a purpose-built family living space connected to a den and a kitchen. It shared 2 walls with the home, a ceiling with the home, a concrete floor with the home, and was enclosed in the front by a planter that had foliage enclosing or blocking off, making more private the portal.
Are you claiming that the planter is the boundary for the portal? Is it your claim that the planter is we've been referring to it as the rock wall, is the boundary to the portal?
I think it contributes to the notion of enclosure, where
If I understand correctly, the cement of the covered portion does not extend all the way to the planter. Is that right?
that is correct.
Okay, so it extends all the way to the planter. There's also like a grill that's off to the side. Is that part of the protected space?
Yes, I believe so. I think the entire portal from the planter to the kitchen wall, from the den wall, I'd even say over to the fence, which is part of the yard, is the portal.
Okay.
It's an enclosed space that puts people on notice. You need to be invited to come in here.
How do you distinguish between defining that as the portal and a situation where you're talking about trespass and jumping over the fence like Fool and Font?
Because if you just jump over the fence in Foulafont, that was a commercial yard that was in full purview to the public passing by. If the defendant had jumped into the yard and passed the portal and went into the yard to burglarize or to steal things from a grill or the pool out there, the fountain rather, that would be probably a trespass. But because he entered the portal, which has doors into the kitchen and into the den, the doors of which were open that evening, and the victim was sleeping in the den. So as he came into the portal, he woke the victim who was sleeping in the space no longer
How do we know
blocked off
that?
by a wall or a door.
How do we know that the defendant entered the portal? What evidence do we have of that?
That he entered the portal,
Yes.
that he jumped over the fence, which is connected to the portal.
Did he he jumped the fence? How do we know he entered the portal?
There was testimony from the victim's wife that she saw them fighting on the portal.
I thought the testimony was saw them fighting in the yard.
No, Your Honor, I believe it was in the
I stand to be
portal.
corrected.
So do you mean the senior justice, you mean just the part that's covered, right?
Yes.
Okay,
So if they were fighting in the yard, they'd be on the other side of the planter, right? So you're sitting on the portal, the planter's in front of you, the yard is beyond. And the planter has foliage growing out of it, which acts like a natural block, a natural wall.
I really struggle with how you're defining portal here, because we can see in the photos, there's clearly a covered portion that has a cement floor. And then beyond that, there seems to be paths that, and an open like dirt area that has a rock wall next to it, and then a path that goes up toward the barbecue grill. How do we define where the portal starts and stops? And how do we write a rule for future cases that tells district courts how to interpret what constitutes the portal?
I think in this instance, and you're right, there is a dirt path, there's a dirt space from the concrete pad to the rock wall you're calling it. I thought it was a planter. That's how I've been thinking of it. But I think the portal, by nature of the rock wall, is confined by the rock wall and the foliage, acting as a natural barrier. How to write a rule? You know, I think it's a case by case basis, and I think the district court got it right in this case. And I think we're focusing so much on the word portal instead of noticing it's a structure, and the structure is connected to the house. It's not only connected, it's one with the house.
is there any evidence in the record that you can point us to that the defendant was in the covered area? Assuming I think that the portal is just the covered area, is there any evidence?
The evidence is that there was the wrestling and the fighting going on was happening under the covered space on the concrete pad in the portal.
What would compel the change in the jury instruction to put portal in parentheses? You say we're focusing on it,
Right.
state focused on it, it was in the instruction, so we are, but it was in the instruction and I am bewildered.
Right. I'm sorry, go ahead.
No, I'm just, why not leave to the jury whether it was the structure or as senior justice just enumerated in the instructions? Or provide the standard in State Office of Public Defender.
Right. I think the reason why the word is just a one word parenthetical in instruction 18, portal. I think it's there because it was being used throughout the trial by witnesses, and perhaps, and this is a guess, so maybe I'm going too far. Perhaps the court just wanted to make sure that the jury understood what structure they were talking about. That, you know,
Well, I think the judge was telling the jury the portal is a structure for
Yes.
purposes of burglary. And if we conclude otherwise, where do we end up?
well, I still think there's an attempted burglary. Even
But
if,
if the attempted burglary instruction is predicated on the burglary instruction, then we don't know what the jury did because it has more than one identified structure. And one of those would be legally deficient. So we don't have any clarity about what the jury decided related to attempted aggravated burglary.
that's correct.
So it would be, do you think it would be direct and free for second degree?
If this court decided that the portal is not a structure under the burglary statute, then yeah, that would be the option.
So you agree to the extent that we disagree with your position, but you agree with defense counsel that the remedy in that instance would be direct remand from second degree, as opposed to a new trial on second degree.
Yeah, if there's no other option after that. And once this court makes that decision, and the evidence that I've seen would mean that portal, if you decide it's not a structure under the burglary statute, it would be a remand for second degree murder.
How do we square your position, your argument about protocol with Mukti?
Well, in Mukeen, they were, like this court said, you know, we need to rein in the burglary statute, right?
The creep.
And so you can't poke in a gas, you can drain gas out of a gas tank without being charged with burglary. And what this court said in Mukeen is that the primary purpose of the statute is protecting the expectation of privacy. From what I read, it's even more important than the notion of property protection. That sense of being violated by somebody entering your private space, that the public is on notice that you need an invitation to come in here. And this case is actually quite similar to State v. Lara, Lara, in which the burglary occurred in a garage that was attached to the house, but did not have a communicating door into the living space. You had to leave the garage through the garage door and then enter the house through the front door or the back door.
But there was no exposed area in Lara. The garage could be completely locked down and the privacy of the garage could be protected by closing the door.
Yes.
Correct?
Yes.
So I don't see this as a Lara type case. It's not a case where, Lara was not a case where there was an open area that could just be traversed by anyone coming by.
I think it's a Lara type case because, as the U.S. District of New Mexico pointed out in an unreported case called U.S. v. Sanchez, that garage was literally under the same roof as the living quarters. This portal was literally under the same roof as the living quarters. It had a ceiling that was the second floor, but it was also under the roof of the living quarters, not connected to the house, one with the house. So this was actually a violation of, in my opinion, the dwelling.
Can I ask you just a clarifying question? And I don't have the attempted aggravated burglary instruction in front of me, so just keep that in mind. So you're conceding that the attempted aggravated burglary instruction follows the regular aggravated burglary instruction and relates back to it. So in other words, if we find a portal is not a structure under the burglary statute, then the attempted burglary statute's not a valid basis to remand back for felony murder? That might have been a poorly worded question.
Well, no, under the evidence that was produced, that the fact that the doors were open, now, there's no evidence that he touched the doors. We presume he was wearing gloves, but there was no evidence of that either. But the fact that the door was open and he was on the portal, you find that's not a structure. He was still heading towards an open door. It wasn't like he passed the port.
But you're missing the point of the question, and it's the question I asked you. Jury instruction number 18, which defines what a burglary is.
Yes.
It's that underlying word burglary says, or portal. So you're looking at jury instruction 19, which by necessity has to relate back to 18 because attempted what includes the word or portal. And so the jury finding, querying what the jury was thinking could have included, oh, it's aggravated because it's the portal. And if we decide portal is not fair game, aggravated burglary is well.
Right.
Attempted.
Yeah, attempted.
But we could, correct me if I'm wrong, we couldn't affirm a felony murder conviction based on the existing jury instruction for aggravated,
Yes.
for attempted aggravated burglary. Could we remand for a new trial on felony murder based on attempted aggravated burglary? With obviously with the corrected instruction.
Yes.
You believe we could?
I believe you could, yes.
Why? If you just answered my question, that if we determine that a portal is not a structure for purposes of burglary, why do you get a second bite of the apple using aggravated burglary as a predicate for felony murder when
Attempted.
attempted,
Yeah.
when portal, if we decide portal is not a structure?
Right.
I don't think you get to jump past the
Well,
fact that the judge added or portal to the jury instruction.
right. I think my thinking is that he was convicted of actual burglary because he was in the portal. If you find that a portal is not a structure, then he wasn't actually burglarizing yet. He was attempting to, in which case the evidence could support an attempt.
But you can't attempt to burglarize something that's not, that we conclude is not a structure for purposes of burglary.
Clearly, the home is a structure.
But you've got the jury considering, is it a home? Is it the portal?
I think we're talking about two different things.
Okay.
I think he's conceded, and you correct me if I'm putting words in your mouth, he's conceded that we can't simply directly remand for entry of a judgment on the felony murder based on attempted aggravated burglary.
Yes.
But based on the erroneous instruction, we could remand for a new trial, and they could start from the beginning and have a trial with a correct instruction about whether he was trying to break into the house.
Except under our sufficiency of the evidence rules, I don't think that.
But it's not a sufficiency. It's going back to rebels.
That's what I was saying.
Have you read 145 New Mexico 110?
145, New Mexico 110.
Yeah, Steve versus Gonzalez.
Have that right. So, right, so in that case, which referred to a Georgia case, and they were critical of the Georgia case because of the difference in the way the statute.
What were the facts of that case?
Open air porch to a commercial structure can be burglarized in New Mexico.
Does this help your case or hurt it?
Pardon?
Does it help? Does Gonzalez help your
I
position?
think it's kind of irrelevant, because it's not been overturned by McDean. Am I saying that right, McDean? But, what? I also think it's a commercial structure. Here, this is a residential structure, the back of the house.
Which you would have more privacy in, right? The residential structure? You would have greater privacy interest presumably in.
Greater expectation of privacy, I think.
Let me,
I guess irrelevant was too strong a word to say that. It just doesn't seem to make a difference.
Okay.
Sorry.
oh, you don't have to apologize. Sure.
Do you have any other questions on that issue?
So, is this time? Is that,
No, he's got time.
we're counting down, okay. So let me read you from State versus Godoy, a Court of Appeals opinion. Where alternative theories of guilt are put forth under a single charge, jury unanimity is required only as to the verdict, not to any particular theory of guilt. And a jury's verdict will not be disturbed in such a case where substantial evidence exists in the record supporting at least one of the theories of the crime presented. Does that language have any relevance to the issue before us here today? Vis-a-vis aggravated burglary versus attempted aggravated burglary. I know
I don't think today it does, because I think today we're talking about whether or not he actually committed burglary by being in the portal. And if you find that it's not a structure, then remand for a trial for attempted burglary. So I don't think that today that language applies, but it might in the next case.
Well, why not? Because the felony murder charge says attempted, that whether they committed aggravated burglary or attempted aggravated burglary, something along those lines. So why doesn't it matter today? The attempt does matter today, right?
Because I was conceding that attempted would have to be retried. because-
Oh, okay.
Yeah.
Thank you.
So we haven't talked at all about the other issue that's raised in this case, which is all the evidence of guns and photographs of guns and ammunition that the defendant raised. If we were to agree with you that the porch is a portal, and so we don't reverse on that claim, what do we do with the claim that the rather significant evidence of guns was overly prejudicial and requires a new trial?
So let me talk about that for a second, because the state notified filed notice that it was going to use evidence of other crimes or other activity. And it was the weapons that were found with the murder. The state also found knives and crossbows. They did not want to proffer that because it was unrelated to 404(b)(2) proffer. So they went through, they had a hearing, the judge excluded all of the gloves defendant had, and they found like 18 of them. Judge excluded the flashlights, an array of flashlights, over a dozen tactical flashlights. Judge said, the flashlight that was found at the scene of the murder, you can use that. The rest are irrelevant. They tend to show propensity and not character, or I'm sorry, not planning. The judge allowed the murder weapon and its second barrel, meaning the gun had been modified for tactical reasons. A gun found with the murder weapon. It also had a modified barrel because it showed it the skill necessary to perform this or to execute this murder. And the judge also allowed a third weapon, a .38, that had not been modified, but as part of the inventory of the execution of the warrant. At trial, when these items were being offered, 13 times I counted, defendant said, no objection to any of the evidence that he's now complaining was erroneously entered. So I don't think the issue has been preserved, in which case you have to find plain error with it rather than harmless error. And even if it was error, and I don't think it was error, and I think if it was error, it was harmless, it certainly doesn't rise to the level of plain error. This did not appeal to the jury's emotions. It was not sensational in that sense. It did not, I don't think you could say that the introduction of that evidence at trial with no objection produced grave doubts about the validity of the verdict.
Part of the gun evidence that troubled me was that there were dozens and dozens and dozens of pictures of the guns. There were hours of testimony about the guns, not just the murder weapon, but the guns and the photographs of the guns and the ammunition and the accessories to the guns. How is that not more prejudicial than?
Because it was offered to show this defendant's intent, special capacity.
How did it show his intent? There wasn't any evidence that he even owned the guns at the time of the murder.
He modified the weapon, the murder weapon, and some of the weapons were also modifications that he performed, and it showed that he had planning in mind. And the other thing the judge excluded, the defendant had a list of houses. Now, the judge excluded it because defendant's house was not listed there. He said it's irrelevant then. So I thought the list actually showed a intent to commit more burglaries. So I think that the weapons that were introduced, murder weapon, of course, is relevant. The second weapon to show that he had that special capacity, and the rest of the weapons, I don't think that you could say that they played on the jury's emotions or prejudiced the defendant in any way like that.
Okay.
Any other questions from the court? Well, thank you. In closing, the defendant received a fair trial. The jury reached a considered verdict, and the court imposed a just sentence, and the state asks that this court affirm the jury's verdict and the court's sentence. Thank you.
Mr. Lewis. 7 minutes.
Thank you, Your Honor, for bringing up the issue of the gun, since I didn't get that in the first part of my argument. The facts of this case, the history of this case, show that it took 2 years for Mr. Jones to be traced by use of some rather cutting-edge genealogical DNA procedures by the Bureau facility. So what was found at the time of the search of his apartment does not at all have probative value at all with respect to his intent, his capability, skill level at the time of crime.
Here's my question for you about the guns. Why was that not harmless error in light of all the other evidence that was presented?
Well, one of the issues that this court has to grapple with in deciding whether to craft a rule about Portal and what degree of protection it's entitled to is the degree of violation that would be experienced by the occupants of the property. In this case, the gun evidence is so incredibly prejudicial. What it does, if it all comes in, or to the extent that what did come in, its purpose clearly is to show super propensity to do home invasions. You have all these weapons, you have tools, you have ammunition.
You agree the defendant didn't object to that, right?
Yes, but
So you agree the standard would be plain error?
But how could it not have a detrimental effect on the fairness of it? Since what we're dealing with is the degree of protection that a homeowner has based on where the intrusion happens to be. And if you present evidence that is overwhelming in its nature, indicating that this person has a propensity to be a serious threat to the life and safety of any individuals who come into his path, how could that not affect the jury in a way that doesn't sway their verdict in ways that are not permissible under our law? There is only one gun that was found in the search of his apartment that could be shown to have been used in this crime. All the others are extraneous. All the others relate to a time period 2 years later.
And what's your response to their argument about the guns being modified? And therefore it showed intent.
One gun was modified, I think, by the use of an aftermarket barrel. That is the gun that was used in the shooting of Mr. Romero. But that argument does not apply to the guns that may have been modified 2 years after Mr. Jones's crime. So there is no time machine here. The jury is being asked to refer back to the state of mind that there is no evidence that Mr. Jones possessed at the time of this act.
I just struggle with the higher plain error standard. How does the introduction of the guns call this verdict into question when you have evidence of the defendant's DNA at the scene? You have evidence of eyeglasses that are the same prescription as his prescription, evidence of, clothing at his home as described by the victim's wife. How does it rise to the level of plain error when you have all of this other evidence that the jury had to consider that was pretty significant?
I would agree that there is evidence of homicide. But again, it refers to the deference or the degree of concern that this court is going to show to the amount of privacy violation that the residents of the house would experience if someone is on their hotel. And incidentally, this may be a sort of off track here, but I think a close reading of the testimony of the trial never does directly establish that Mr. Jones was on the hotel, because in some descriptions we have, he was by the flower bed, he was by the gas grill, he was by the pony wall. So it's never conclusively established by the evidence in this case that he was actually even on the hotel. But also resolving this question of the extraneous weapons is important if the court decides to grant a new trial. Based on the wishes of the state. I'd also like to respond to something that council said about the Portal sharing a roof with the main residents, and one of somewhere in there's reference, or rather a critical reference to the Texas case, Richard v. State, in which the Texas Court of Criminal Appeals wrote about the claims of dwelling being extended, and if it's within the geospatial extension of the planes of the house, it's protected space. And this court of appeals said this is unnecessarily complicated and it's putting too much of a burden of speculation on the part of the court of the courts below implementing that. And so it did away with it. This court said, no, we're not doing that. We're not going to adopt a plains analysis. And I think the court referred to that kind of analysis as resulting in.
But the plane was going from the house to the car.
We do not-
That's what the court was criticizing, correct? I mean, I don't want to get into planes and I'm not any good at geometry. But do you agree in that case, the criticism was, can you go from the house to the vehicle where you penetrated the?
Well, in effect, that's what counsel is asking this court to find in this case, that the plane of the roof of the main residence has something to do with the coverage of the hotel. And I see that I'm almost out of time. If there are any other questions.
Thank you, counsel. In the matter of S-1-SC-39949 State versus Jones. Court, the matter is now deemed submitted to the court. We thank you for your presentation and your briefing in this matter. Court is in recess till 1:30.